versus Javar Tyrone Grayson, case number SP 146436761, SP 146409991, SP 1463900, counts 1, 2, and 3. State your name for the record.
Grayson
Bay. I'm sorry.
Thank you.
State your name for the record.
Grayson Bay.
All right. This is today is the date and time set for a jury trial. Ms. Schneider, can you put your appearance on the record, please?
Good morning, Your Honor. Alexis Schneider for the people, P80322. For the record, the issuing officer, Officer Ambrose, was present, although I released him.
Mr. Grayson Bay, we didn't conclude some of the. First of all, I want to get the record straight from yesterday. I did mention, and you did cite. Where's Mr. Grayson Bay's file? Yes, but I brought it back downstairs. Yes. I wanted to clear up something I said on the record as far as the case that you cited out of Alabama. That I was incorrect as far as the facts of that case.
Witness the moment where the courtroom energy shifts instantly from casual to serious. The judge formally opens the case. The prosecutor steps in, and the defendant identifies himself, setting the tone for everything that follows. This part feels calm on the surface, but it carries that quiet tension that tells you something heavy is about to unfold.
Not the case where they were walking down the street and did not obtain the license to assemble. That was a case where he has another reverend organized a sit-in and at a restaurant, and they were ticketed. And the unfortunate part about it is, and that's just how our society is, and it was, and still is for the most part, is that this case had to go all the way to the United States Supreme Court for him to get justice on this case. But again, you're citing cases, sir, that you're not even reading with the.
Buckle up, guys. Today we are going to see the courtroom temperature rise as the judge directly challenges the defendant's legal logic. The exchange becomes sharp, uncomfortable, and revealing as the defendant tries to stay silent while clearly being cornered by facts. You can feel the authority of the bench tightening the grip on the situation in real time.
That's something a lawyer would be could be brought up to the grievance commission on and potentially lose their license. All the cases in there, all the cases that you have cited are saying exactly the opposite of what you purport. Have you looked at any of them?
Yes, Your Honor.
And you read them? When did you do that last night?
I've been studying more science. My religion is more science. As you can see, if it looks like a duck, it acts like a duck, it tells you it's a duck, it's pretty much a duck. So I'm more science. So I've been studying for over 10 years.
All right, guys, this is where the courtroom hits a turning point because the judge moves from questioning to actual rulings. The charges are addressed one by one, the tone becomes colder, and the consequences move from idea to reality. This part feels heavy because it's where words become penalties and the reality of judgment lands hard.
But you haven't been studying.
No disrespect to you, Your Honor. I just want to remain mute to the fact and acknowledge that my mother is here, the matriarch of my family. And so I just want to remain mute to this case in this matter. And the floor is yours. This is your courtroom. No disrespect. My mother is here.
No. Ma'am, can you stand up and state your name, please?
My name is Mary Grayson Hall.
Good morning, Ms. Grayson Hall. And it's nothing about you can see it. I just wanted you to acknowledge. I do acknowledge the fact And I appreciate the fact that you have support here. The court always recognizes that. That's why I asked you to stand up. But you want to remain mute now. But you didn't remain mute when you filed these pleadings. This is how you speak to the court, exactly the way you did. Now, maybe the form is not exactly the way the court kind of or the rules have applied, but I understand you're in pro per and you might not know all of those rules. But when you start filing these documentations, you're speaking to the court and you're representing that this is the current state of the law as this is the current state of the law, and this stuff applies to your case, and I should be reading this stuff and be able to interpret what you're saying about your case through these cases. And when I read these cases, it says exactly the ones that I've read, and I've seen these cases filed before, it says exactly the opposite of what you're trying to say. Because what I understand you're trying to say is that you're trying to say that you don't need a valid driver's license to drive on the roads, you don't need proper registration on your vehicle, and you don't need proper insurance. And you're even going as far as saying that the police officers, and correct me if I'm wrong, that the police officers do not even have the authority to pull you over. Is that correct?
Again, Your Honor, I remain mute to the situation.
Buckle up, guys. Here we watch the official mechanics of justice in motion as charges are dismissed and fines are discussed in clear, procedural language. This part shows how quickly a courtroom can transition from chaos to structure, and how decisions that change someone's future are handled with calm, professional precision.
My mother is here. No due respect to the court. My matriarch is here. And I gave you pretty much documents to read. And I'm standing on those documents, and I'm gonna remain mute. Thank you.
All right, so I've already found you guilty of the count of refusing to exhibit a driver's license, SP 1464091. I'm going to fine you on that case $240. I've already found you responsible on SP 1463901. Expired plate. I'm going to fine you $145 on that. And I've already found you responsible on SP 1463903, insurance no proof, and I say guilty on SP 1464091, and that's a 240 for the insurance no proof. I'm going to fine you $195 on that. All right. As far as the other counts, I had in the note. Well, you told me off the record that you're going to dismiss SP 146436761 and SP 146390002. Is that correct?
That's correct, Your Honor.
So 145, 195, and $240, sir. When can you pay?
I will probably need after the holidays, maybe 3 months. I might get something up for you.
Are you working?
I do carpentry.
Yeah, you do carpentry. Are you working?
Yes. Yeah, I have jobs lined up.
Okay, so why do we need so much time?
They lined up. They're not completed. They're just future jobs.
All right, guys, this is where the tension becomes personal. The judge questions the defendant's work life and financial reality, and you can hear the frustration creeping into every answer. This moment exposes the gap between what the defendant claims and what the judge believes, creating one of the most uncomfortable and revealing exchanges in the entire flow.
You're not working.
Today I'm not in court.
You got this play on words.
Yeah, I mean, traveling and
Is this
driving. Yeah, there be the system. Play on word. I mean, it's the truth though. I mean, I gotta speak the truth to you, right?
You're
respect
not
the truth?
working now. If you.
Okay, I'm not
asking
working
you-
today, I'm not working.
No. You're not, I'm asking you, why is it taking you
We-
3 months to get up? I don't typically give out 3 months to pay fines, especially when somebody's working, and especially in a career that's a skilled trade, that's a very lucrative career. So I'm trying to give you the time you need, but I need to make a good basis for that.
3
Because
months.
you're not giving me a good basis for giving you 3 months, and you're telling me you're a carpenter and you're telling me you're working. Now, if you're telling me you're a carpenter and I'm not working currently, then that's something that I can go with. But you're telling me I'm just not working today.
Right.
I'm gonna go to work tomorrow.
Well, we
I'm
optimistic,
going to work
yeah.
tomorrow, and I'm going to work the next day.
Yeah.
So I'm not giving you 3 months.
Very
for that.
optimistic, that's why I said, well, as this present, not, but yeah, tomorrow, I'm very optimistic about work, so yeah, yeah.
So you're not working.
Today, I'm not working. Tomorrow, I have grass work tomorrow to do. There are schedules to do, and I do have a future as a job to have things to be done, but as you saying, as I'm working, I'm telling you the truth, not as now, no. If that clears, if that makes you feel comfortable, no, I'm not working.
I'm trying to ascertain.
No, I'm
what's
not
going
working.
on, sir.
I'm not working. At this present moment, I'm not working.
And when you say you're working, you have some aspirations of working,
Yes.
like everybody does. We're
Yes.
looking for, well, not everybody, because not everybody is trying to work.
Right, exactly.
So
Yes.
you're not working now,
Right,
correct?
thank you, Your Honor.
Let me ask you this, ma'am. Is this the kind of, I don't know, I want to make sure that you don't need any mental health services? Do you?
Are you questioning?
Buckle up, guys. Now we enter the most intense emotional territory of the hearing. The judge openly challenges the defendant's mental clarity and honesty, pushing hard for straight answers. The courtroom feels heavier here because it's no longer just about laws or fines, but about personal responsibility and reality colliding in front of everyone watching.
I mean, you're giving me these play on words. You're giving me all of this
Speak the
stuff.
truth,
You-
Your Honor.
you- I don't
Speak the truth.
I don't feel you're speaking the truth to me.
I'm not working today at this present moment. I'm not working.
And you're not working, you don't have anything set for tomorrow,
No, I don't.
right?
Nope, I don't. I don't.
You don't,
I'm
do you
not
have
even
anything
working.
set for next
Nah.
week?
No, I'm just anticipating things. You're right. I don't.
Do you understand what I'm saying?
Exactly.
I'm just gonna get you out of here. I'm gonna give you, till March the 5th. You can either Zoom in or come in. I'm gonna give you till March the 5th to have the stuff paid off, all right?
Can I get a total of that?
All right, guys. This short moment carries serious weight as the judge delivers a clear deadline and effectively draws a hard line in the case. It's brief, but powerful, showing how a single ruling can close a chapter and leave no room for negotiation, excuses, or delay.